We are This month we are happy to have a very interesting topic, which affects persons not only in the construction industry but across various sectors and various industries. My name is Vincent Jones, and I am your moderator for tonight's session. Just as a reminder, this is a CPD event, and we would ask that if you are a professional and you are joining us for the first time, if you're interested in claiming your CPD points, please contact the Barbados Association of Professional Engineers Secretariat, and Stacy at that end will be happy to share the necessary information with you so you can submit to your professional body for CPD purposes. Just to give you an outline of tonight's session, we will usually have our introduction, which we are doing now. Our presenter is going to present for between 30 and 40 minutes. And then we invite you to engage in a question and answer segment at the end. We would want you to participate. This is participatory. So once our presentation aspect is finished, please feel free to engage. And you can do that by either raising your hand and I will acknowledge you in turn. Or if you're feeling a little camera shy, you can put your question to our presenter and I can ask that question on your behalf within our meeting chat and I can convey that question for you. So tonight's topic is titled Dispute Resolution, Arbitration, and the Building Professional. And we're going to be discussing this evening types of dispute settlements mechanisms, disputes arising under building contracts, what constitutes an effective arbitration agreement, the steps in the arbitration process, the arbitral tribunal, and the role of the court. And we have presenting this evening someone extremely knowledgeable in that area, Miss Nicola Berry, who is principal and attorney at law and an arbitrator at Berry's Attorneys and Arbitration. So she and her husband form a formidable team, and they have been in the business of arbitration for some while. We also are fortunate this evening to have with us a speaker, or rather a presenter from our May session, who also happens to be involved in dispute resolution, and that's none other than Mr. Miles Weeks. So we do have several professionals in the space this evening that should be able to answer your questions and give actual examples for those of you who may want to engage at that level. I can see we have a good spread of professionals in the room this evening. I see engineers, architects, and some lawyers, so that's great. And I really expect that we're going to have an interesting session this evening. So I'll let Nicola do a brief introduction of herself, and then she can commence with her presentation. So Nicola, thanks for having you. Can you hear me?
Yes, I can hear you. Can you see me and hear me?
And we can see and hear you. Great. So
Okay,
introduce
great.
yourself to our professionals, and then off you go, Nicola.
Okay, great. So good evening, everyone, and thank you to the Barbados Association of Professional Engineers for having me this evening and for providing me with an opportunity to discuss dispute resolution, arbitration, and the building professional. So I am an attorney at law by profession and also an accredited arbitrator. I have my own practice. It is called Barbados Attorneys and Arbitrators, and we're generally a law firm which provides corporate, or main practice area is corporate commercial law, and we also have accredited arbitrators in our practice. So that is me in a nutshell. I am unable to see you on screen right now because my presentation has been loaded. And so without any further ado, I will get right into it. So once again, thank you so much for having me this evening. And it's great to hear that I have some colleagues, including Mr. Miles Weeks in the audience. Okay, so let us get started. So this evening, we are going to be covering Firstly, the types of alternative dispute settlement mechanisms. I will then move to look at the dispute resolution provisions in certain building contracts. And then the rest of my time with you will be spent discussing arbitration, and in particular, drawing a distinction between domestic and international arbitration, looking at an effective arbitration agreement, general steps in the arbitration process, the arbitral tribunal, and the role of the court. So my objectives today are that at the end of the day, I would hope that you'll be able to outline the dispute resolution mechanisms on the selected building contracts, identify essential elements of the arbitration agreement, explain the general steps in the arbitration process, review the role of the arbitral tribunal, and also explain the role of the court. So let's get started with the types of alternative dispute settlement mechanisms. All of us are familiar with negotiations being top of the list, but there is also neutral evaluation where the parties arrange for a neutral party who will listen to each side and give a non-binding opinion about an issue of fact, law, or a technical issue. There is the expert determination where the parties can agree that a dispute should be resolved by an independent third party with expertise in the subject matter. There is also what can be many private trials. And then there are the dispute boards. We have the dispute avoidance board, dispute review board, dispute adjudication board. And with the dispute avoidance board, the parties are free to approach the board and jointly refer a matter to it with a view to providing assistance or informally discussing the matter with them. And such informal meeting may take the form of a site visit. There is a dispute review board, which issues recommendations, and if no party expresses dissatisfaction, the parties can agree to contractually comply with their recommendations. And then the adjudication board issues decisions on any dispute referred to it. It provides a temporal finality. And by contractual agreement, the parties must comply with the decision of the adjudication board. FIDIC, which I will make mention of later on as well, has adopted the adjudication board for international construction projects, and members must be independent and impartial with no financial interest in the project. And that board convenes for regular on-site inspections. Mediation is another form, and mediation involves a neutral third party assisting the parties to work towards a negotiated settlement. Then there is adjudication, and a number of the building professionals would be familiar with adjudication, whereby an independent third-party adjudicator gives an independent decision on a dispute which must be implemented. And of course, there's arbitration, which involves an impartial tribunal determining a dispute. Of the list that I just went through, the mechanisms that are most controlled by the parties include negotiations and mediation, and mechanisms involving a third party neutral, but with minimal requirements of due process would include a neutral evaluation, expert determination, and dispute review boards. The mechanisms that are more process-driven would include the dispute adjudication boards, many private trials, adjudication, and the arbitration. Now, disputes arise in various ways under a building contract. And these issues which may give rise to dispute include matters where there is the budget is exceeded. So the question of who pays for the costs that exceeds budgeted costs, the contractor or the employer. Then there are claims relating to time and delay, defect, quality, and performance, and payment and variation disputes. International construction disputes are by nature complex and technical, involving multiple parties. There needs to be a clear structure for the management and resolution of disputes. And this is where the dispute boards tend to have a lot of value. So the building professional, including engineers, may be called upon to perform any of the following roles in the resolution of a dispute, depending on qualification and experience: neutral, expert, party representative, mediator, adjudicator, arbitrator. And to the extent that a building professional is not called upon to undertake such a role, it is still critical that each type of building professional understands what is involved in these processes and what is at stake, so that at least there is that not only understanding, but the ability to ensure that disputes can be managed in an effective manner. I had a look at some of our templates or contract templates that are used in our construction industry. And I have worked on FIDIC and JCT contracts in my professional job as an attorney, and EPC contracts. So we have the Barbados Association of Quantity Surveyors standard form of house building contract. There is the BIA Minor Works Agreement that I had a look at. Then there is a JCT building contracts. We have the FIDIC suite of contracts, green, red books, etc. Now, when you look at these contract templates, you'll see that dispute resolution is provided for with the Quantity Surveyors Association standard house building contract. It provides for adjudication, and then failing that, parties can take the dispute to the courts for the courts to resolve the dispute. Then there is the Barbados Institute of Architects Minor Works Agreement, which provides for arbitration. The JCT Standard Building Contract provides for a tiered process or several ways in which disputes can be managed or resolved. Negotiations, mediation, it says it should give the parties should give serious consideration for mediation. Then there is adjudication. And after that, depending on what is provided for in the contract, it could be arbitration or legal proceedings before the courts. In the FIDIC Red Book, 2017, and I know we have, this is the Engineers Association, and so I wanted to highlight the role that engineers can play under those contract or this type of contract, or the FIDIC contracts, I should say, with the provision for the engineer's determination. And so the engineer is first required to consult with the parties and encourage discussion to try to reach an agreement. If no such agreement has been reached within a 42-day period, or if both parties advise the engineer that no agreement can be achieved, then the engineer shall make a fair determination of the matter. The engineer's determination has to be made within a 40-day period, and it has to be described in detail with reasons and details supporting particulars. The engineer has a duty to be neutral, and the engineer's determinations are binding on the parties unless they're revised by the DAA, the board, dispute adjudication board, or in a subsequent arbitration. So the engineer, under the FIDIC form of contract, does play a role in the dispute resolution process, as the engineer is able to make a determination on certain matters. Clause 21 of the FIDIC Red Book outlines the dispute resolution and arbitration provisions, and provision is made for the dispute adjudication board to first resolve a dispute, and then if at the end of that determination, there can also be room for amicable settlement before the parties finally resolve their dispute by arbitration. And this here is a picture that is of the sequence of dispute events that's envisaged in clause 21 of the FIDIC contract, Red Book contract. And this is from the FIDIC Red Book as well, this presentation of the dispute resolution sequence, outlining the involvement of, firstly, the contractor receives a letter of acceptance, and so the parties appoint the board, the dispute is referred to the board, the parties present their submissions to the board, there is a time period for this to be done, then the board needs to give its decision within a certain time period. And then if there is a notice of dissatisfaction is filed if a party is dissatisfied. But there is also an opportunity for an amicable settlement before an arbitration is launched. And the type of arbitration that's provided for in the Red Book is an ICC form of arbitration governed by the ICC rules. So what you see coming through these building contracts, or some of them, is that we have provision for multi-tier dispute resolution clauses. And this is where you have separate dispute resolution procedures at different stages. The stages are distinct and escalating, engaging different personnel and expertise. Where a dispute resolution provision follows a multi-tiered approach, it is important to consider whether those tiers are intended to be binding and whether a party can skip a step in the escalation of the dispute through the tiers. Failure to comply can result in jurisdictional challenges to the arbitration and a stay of proceedings. So if it is that a particular tier cannot be skipped in that dispute resolution process and a party does try to skip it, then the other party will rightly be able to mount a jurisdictional challenge to that arbitration and to seek a stay of those proceedings. So, what is arbitration? And I will focus the rest of my discussion on our presentation on arbitration. So, arbitration is a dynamic and binding private mechanism for dispute resolution. It is conducted before an impartial tribunal and is attractive to parties because it is created solely by their agreement. In an arbitration, you have that neutral third-party tribunal that makes a final determination, which is the award, which is a binding decision based on the evidence and arguments presented by the parties. And the power to challenge an award is limited in most jurisdictions. The power of the arbitrator is derived from that commercial agreement, that building contract, in this case, between the parties to submit their dispute to arbitration. So if I wanted to then move on to look at our legal framework supporting arbitration, and we do have the Domestic Arbitration Act, which supports or governs domestic arbitrations. And we have the International Commercial Arbitration Act and the Arbitration Foreign Arbitral Awards Act, which govern international arbitrations. So that's generally our legal or statutory framework. Our Arbitration Act, which governs domestic arbitrations, is archaic. It's a 1958 piece of legislation. And I am well aware that the work is being undertaken for us to have a modern piece of legislation that can govern both our domestic and international arbitrations, because we do have a modern piece of legislation which governs our international arbitrations, but we have to address our local Arbitration Act. It has not kept up with the developments in the conduct of arbitrations. And for example, the preservation of the parties' autonomy. It maximizes opportunities for the intervention of the court. But thankfully, we've had a judiciary that has restrained itself when it needed to, although perhaps parties involved in proceedings before them may have their own views. But there's also no built-in timelines for like the appointment of the arbitrator or to drive the process along. And so you do have mandatory provisions that have to be addressed because they're archaic. So our International Arbitration Act, it defines an international, or it sets out when an arbitration is international. And so once the arbitration satisfies this definition, then it can be governed by that legislation. And it says it's where the arbitration is international, where parties to the agreement have, at the time of the conclusion of the arbitration, their places of business in different states. And that's the world that we live in now. it's where one of the following places is also situated outside the state in which the parties have their place of business. And that is the place of arbitration under the arbitration agreement, or any place where a substantial part of the obligations of the commercial relationship are to be performed, or any place with which the subject matter of the dispute is most closely connected, or the parties have expressly agreed that the subject matter of the arbitration agreement relates to more than one country. And there are provisions dealing with where there is more than one place of business or no place of business, and how that is dealt with. So I wanted to highlight the statutory framework that we have here, and the definition coming through our International Commercial Arbitration Act, because within the building industry, increasingly we see where you have projects involving parties from maybe from overseas coming into Barbados, or you have different expertise that may be relied upon, and so you have joint ventures, and so you may find that some of the nature of the contracts which exist for certain projects may involve a dispute may give rise within that contract. And firstly, of course, you have to look at the provisions there governing the dispute resolution. But to the extent to which our law is the applicable law, then the International Commercial Arbitration Act would be applicable. So it's important to understand that while we have domestic arbitrations, which may be governed by the Domestic Arbitration Act, we do have that International Arbitration Act that would be applicable to those international arbitrations. And there can be, and I can qualify that further to say where they're seated in Barbados. Now, in preparing an effective arbitration agreement, it's important to understand that, and a little later, I will go into some of the things to look for in that agreement, because the more of these things you find in the agreement, then the better or the more likely it is that the arbitration will save time, cost, and will be able to move on with greater speed. But before I know those things, I just wanted to highlight that in order for that arbitration agreement to be valid, it should be in writing. It should deal with existing and future disputes. It must, which arise in respect of a defined legal relationship, whether contractual or not, which concern a subject matter capable of settlement by arbitration. The parties to the agreement must have legal capacity under the law applicable to them. And I thought of an example here where if you have an entity enter into a contract without the proper resolutions and the required voting for that resolution being in place, those things can give rise to a party not having the requisite legal capacity to make that contract for the agreement. The agreement must be valid under the law to which the parties have subjected it, or failing any indication thereon under the law of the country where the award was made. And these things are important because when it comes to the enforcement stage of any award, it's going to be important to meet the requisite criteria, which includes these things. So I mentioned that it should be in writing. And I wanted to go back to our Domestic Arbitration Act to highlight that this act does make provision for our arbitration agreement to be in writing. And we have the case, which a number of us will be familiar with, of C.O. Williams Construction Limited, which the question that was considered by the court in that case is whether there was a submission to arbitration by a party in that case, because the court found that the parties had failed to execute a formal contract, and because the arbitration clause was contained in an unsigned unsigned subcontract. And so the court found that because it wasn't signed, then there wasn't an agreement in writing. And so as a result of that, the proceedings were not stayed. So it is important to understand, however, beyond Section 2 and the Arbitration Act as what constitutes writing. Because under the Arbitration Act, we have where this case failed and the proceedings were not stayed because you had an unsigned contract. But again, the law and the provisions governing what constitutes in writing have evolved over time. And in our International Commercial Arbitration Act, we see where the arbitration agreement may be in the form of an arbitration clause in a contract or a separate agreement, but it shall be in writing. So it is not it's not restrictive as the Local Arbitration Act. Now, the unofficial model law, and this is really the model law for international arbitration legislation or legislation making provision for international arbitration. And it presents some other options in terms of the definition of this arbitration agreement in writing. So there is an option of a revised definition, which may be adopted by states. And that's option 1, where no requirement that the parties sign the arbitration agreement. So there are some states who can adopt this option where there's no requirement for signing. Or you have another option which does not specify any form of agreement. And so the question of whether recordings could constitute an arbitration agreement has been asked. However, there will be difficulty in enforcing an award which is based on an agreement, an arbitration agreement, which is based on a recording, because the New York Convention, which is the convention which allows for the enforcement of international arbitration awards, does make provision for the agreement to be in writing. And on that note, I just wanted to use this opportunity to highlight that the following pieces of the following combination of this convention, the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is called the New York Convention, and of the rules, the UN arbitration, the UNCITRAL arbitration rules, and the model law. These 3 pieces of international instruments, so to speak, have been contributed to for the success of international arbitration, because where states have signed on to the New York Convention, what it means is that a party with a valid award can go to any of those states where the other party has assets to enforce the award. The rules, the UNCITRAL arbitration rules, have been used and by persons across the globe, and they're considered to be the best, international standard. But of course, there are other arbitral rules that are available and utilized, such as the ICC. And then there is a model law. We are a model law country because our International Commercial Arbitration Act is based on the model law. But these 3 pieces are kind of the pillars of the instrument. These are the pillars within the international arena in terms of the rules that facilitate international arbitrations. Okay, so we know that it must be a valid agreement, and we looked at what constitutes in writing. And there are some drafting issues and things that, I would hope that when you next see an arbitration agreement, if you're not as familiar, for those of you who are not as familiar, that you will look for some of these things to be satisfied that you're getting, or this clause is the best clause. It is representing what is best practice. So that clause can provide and should provide for a number of arbitrators, what the seat of that arbitration is, whether you're going to have it being an ad hoc or institutional arbitration, what rules will govern that process, arbitration process, what is the law governing the agreement, what's the language of the arbitration, and provisions regarding confidentiality. So number of arbitrators, in most cases, it's either one or three, depending on cost or rules or agreement. At the end of the day, the agreement of the parties. And so if you have a clause that just says we can go to arbitration if there's a dispute, that is not a good enough clause. I can tell you that. Because what it means is that when there's a dispute and you get to that arbitration, you're like, parties are scratching their heads like, okay, what do we do with this? How do we move forward with such a general clause? And so if you carefully, when you are considering your contractual arrangements, look for a couple other things that could help the process along, then one of those things would be making provision for the number of arbitrators. I mentioned the seat, and the seat in this case is that legal location of the arbitration. And for those contracts in which the parties may not be using like the FIDIC or any other established form of contract, and there's more room for parties to determine what this process should look like. And particularly if it involves international parties, you want to be thinking about what should be that legal location of this arbitration. And that location, it is the source of the juridical law that will apply to the arbitration process itself. So it doesn't necessarily have to be the venue for the hearings. That can be anywhere in the world. However, the seat provides the necessary legal framework for the proceedings. It is the seat, the courts of the seat will have that supervisory powers over the arbitration. So if you choose a seat in which it's not a model law country, then you're gonna run into some issues if the arbitration needs to be considered because the framework is not there to help the process move along. So if Barbados were designated the seat of an international arbitration, the International Commercial Arbitration Act would be applicable. And so the provisions there regulating and setting out the role of the court would be applicable. So when selecting the seat, it is important to consider the effect it may have on the conduct of the arbitration and the potential enforceability of the ultimate award. The procedural law of the seat in some of the more arbitration-friendly centers of the world tend to have fewer mandatory procedural provisions and keep the role of the courts at a minimum. The seat of the arbitration is also critical for enforcement. By selecting a country which is a party to the New York Convention as a seat of the arbitration, the parties establish a good basis for their awards to be enforceable. Another thing to consider in developing the arbitration agreement in the contract is this arbitration going to be ad hoc or institutional? In other words, is there going to be an institution which administers and supervises the arbitration process and the arbitration follows the rules of that institution? Or is it going to be ad hoc, one in which there's no institution to administer the process, but instead the arbitration is run by the parties and the arbitrators? And you find that even in some joint venture contracts as well, you may find that where parties are building out their agreements, they may consider, are we going to have an institutional arbitration, or will it be ad hoc? And so where you have an arbitration that is ad hoc, then what it means is that the arbitrator will then, or arbitrators will then have to determine some additional things, such as the rules that should govern the arbitration, and whether there should be someone, a secretary to the tribunal, assisting in the administration of that arbitration, because there isn't an institution involved with that or making provision for that administration. And on the matter of institutions, I should mention that we, in Barbados, we do have the AMCC. I think most of us are familiar with the AMCC as our local arbitral institution, which has been established, and it has its own rules for not only domestic, but also international arbitrations and mediation. And the AMCC is one of those bodies with the capacity and to be able to assist with the management, the administration of that arbitration. Yes, and that's my plug for the AMCC. So what will be the choice of rules? Again, going back to the ad hoc type of arbitrations, the arbitrator, one of the first duties, if the rules are not spelled out in the contract as to what rules will govern the arbitration, then it will be the duty of that tribunal, along with the parties, to establish what the rules will be. But a properly drafted arbitration agreement should provide for which rules of procedure should apply. And where there's uncertainty in the arbitration agreement, the arbitral tribunal will be required to assess which law or rules apply. But there are mandatory laws which the rules will not be able to nullify. And these are laws at the seat. So most institutional arbitrations would generally be based on the rules of the institution, which are mostly based on the UN UNCITRAL arbitration rules. There are, however, differences between the various rules which should be considered, and many parties use the UNCITRAL arbitration rules for ad hoc arbitrations. But of course, as I just mentioned, there is the AMCC with its arbitration rules as well. And as I mentioned earlier, the FIDIC provides for ICC rules. And so you have to understand the rules that may be attached to the particular building contract that you're employing, because they may have built in a set of rules already. And just a little bit more here on the UNCITRAL rules. These rules cover the notice of arbitration, the response to the notice, designating and appointing authorities, which are sometimes required for the appointment of the arbitral tribunal, the number of arbitrators, the challenge of arbitrators, the replacement of the arbitrator, and rules governing the proceedings. So details about the governing process. And then the governing law of the contract should be stated in the arbitration agreement unless it is stated elsewhere. And the language is important as part of the arbitration agreement clause, because sometimes you do have witnesses that may speak different languages. And so if the parties, depend on where the dispute originates and where it's being performed, from as early at the contract drafting stage, the parties should consider language, because it can take on a certain level of importance in certain types of arrangements. And confidentiality, although arbitrations are generally private, the extent to which confidentiality of the arbitration is protected varies depending on the applicable law or rule. And so the parties may wish to make an express provision that the proceedings will be confidential. And I have some examples here of arbitration clauses. The ICC provides that all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber in accordance with the said rules. And parties are free to adapt the clause to their particular circumstances. For instance, they may wish to stipulate the number of arbitrators, given that the ICC arbitration rules contain a presumption in favor of a sole arbitrator. The party should also add the place and language of the arbitration. And if the parties wish to exclude provisions, for example, any recourse to the emergency arbitrator provisions, they must expressly opt out by adding the following wording to the clause that the emergency arbitrator provision shall not apply. And I mentioned AMCC earlier, and the MCC, they have a form of mediation and arbitration clause. And I did mention earlier the multi-tiered clause that is valuable and is present in some of the more extensive contracts. And this clause outlines, if you look in the clause, you'll find some of the things I mentioned earlier. It talks about in the event of a dispute, controversy, or a claim arising out of, relating to, or in connection with this contract, including with respect to the formation, applicability, breach, termination, validity, or enforceability thereof, the parties shall first seek settlement by mediation under the mediation rules. And then if it's not settled by mediation within a particular time, the parties then can agree to have it settled by arbitration. And the rules are cited there under the arbitration rules of the Arbitration Mediation Court of the Caribbean, which is a long name for the AMCC. And it talks about how many members of the tribunal, where the seat of the arbitration is, the language, and the governing law. And so that is the form, the way, that's how the contract or the arbitration agreement should appear, where you are dealing with a contract in which you are developing that part of the arbitration agreement in the contract. So the general steps in the arbitration process involves the filing of the request for the arbitration. There is an arbitrator or a selection process. There is going to be a preliminary hearing with the arbitrator or arbitrators, at which certain things will be organized, such as the rules governing the arbitration, whether, who will be providing certain administrative services. If it's an institution, then that is it's already, and if that is written into the agreement, then it's already clear. But if it has to be determined, then a determination has to be made as to who, what, and the cost. It may be that the arbitrator, for maybe where a sole arbitrator is appointed, and for maybe smaller disputes, the arbitrator may not have that need of getting that administrative assistance. Issues relating deposits in respect of costs, witnesses to be called, including expert witnesses, the hearing dates. Then there is going to be that discovery process where documents may be shared or exchanged. And of course, there's a hearing, and which involves submissions being made as well. And then there is a final award. A note on the award, and taking this from our International Commercial Arbitration Act, the award shall be made in writing and signed by the arbitrator or the arbitrators. In arbitral proceedings with more than one arbitrator, the signatures of the majority of all members of the arbitral tribunal shall suffice, where the reason for any omitted signature is stated. And the award shall state the reasons upon which it is based, unless the parties have agreed that no reasons are to be given, or the award is an award on agreed terms under Section 43. And the award shall state its date and the place of the arbitration as determined in accordance with Section 33(1) or 2, which really just sets out whether the parties had agreed to the allocation being the seat, or whether it had to be determined by the arbitrators themselves. And the award shall be deemed to have been made at that place. After the award is made, a copy of the award is signed by the arbitrators in accordance with the section mentioned earlier, and it's delivered to each party. Now, just to talk a little bit about the arbitral tribunal, because it is quite a weighty responsibility to be an adjudicator where someone has to play that role as an adjudicator or an arbitrator. In fact, it is a weighty responsibility to be to have to make a determination on a dispute which arises. So even as I mentioned earlier, engineers sometimes are called upon under the contract I mentioned earlier, the FIDIC contract, to make a determination. So as it relates to the arbitral tribunal, our International Commercial Arbitration Act makes provision that the parties are free to determine the number of arbitrators. Where the parties fail to make a determination pursuant to subsection 1, the number of arbitrators shall be 3. And no person shall be precluded by reason of the nationality of the person from acting as an arbitrator unless the parties otherwise agree. The impartiality of the tribunal is critical. And where a person is approached in connection with the possible appointment of the person as an arbitrator, the person shall disclose any circumstances likely to give rise to justifiable doubts as to the impartiality or independence of the person. And this is an ongoing responsibility of the tribunal, because circumstances may change or arise, resulting in additional disclosures needing to be made. But if there are any justifiable doubts, if someone is approached, if a building professional is approached to be an arbitrator and that person has a justifiable doubt as to his or her impartiality or independence, that person should decline the invitation or the opportunity to be appointed. And sometimes and there's a lot of discussion and there are rules governing conflicts of interest of arbitrators that are available to help someone understand when it is that the issue that they may be thinking through is one that is sufficient if they disclose that issue, and then and those rules and guidelines can also assist in highlighting that maybe this is an issue that cannot only be disclosed, but it should result in a person refusing appointment. But that impartiality is critical, because if it is that a party doesn't, and sometimes a party may not think that the arbitrator is impartial, but that may be a matter of perception. But at the end of the day, a party can challenge the award if it is that it has been revealed that the arbitrator was not independent. Okay, so I'm getting there. I'm almost there. So, and an arbitrator shall, from the time of appointment and throughout the arbitral proceedings, without delay, disclose to the parties any circumstances referred to in subsection 1, unless the parties have already been informed of them by the arbitrator. An arbitrator may be challenged only where circumstances exist that give rise to justifiable doubts as to the impartiality or independence of the arbitrator, or the arbitrator doesn't possess the qualification agreed to by the parties. So if an arbitrator is appointed, then the parties can challenge an appointment on these bases. And a party may challenge an arbitrator appointed by the party or in whose appointment the party has participated only for reasons of which the party becomes aware after the appointment has been made. Note that an arbitral tribunal may rule on its own jurisdiction, including any objection with respect to the existence or the validity of the arbitration agreement. And for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. So we're going to end on the role of the court. So the state courts in modern law countries play a vital complementary role in the arbitral process, supporting the arbitration by preventing parties from circumventing the process in breach of an arbitration agreement. So the court can stay proceedings in favor of arbitration, for example, or help with the appointment of arbitrators. So the court can provide that complementary supporting role. Under International Commercial Arbitration Act, a court before whom an action is brought in a matter which is the subject of an arbitration agreement shall, where a party so requests, not later than when submitting the first statement of the party on the substance of the dispute, refer the parties to arbitration unless it finds that the agreement is null and void, inoperative, or incapable of being performed. So here we see a provision supporting that alternative dispute resolution process, which the parties would have agreed to in their contract. In Section 12, it provides that it is not incompatible with an arbitration agreement for a party to request from a court before or during arbitral proceedings an interim measure of protection and for the court to grant such a measure. And the court may set aside the appointment of an arbitrator as well. And as it relates to interim measures, an interim measure issued by the arbitral tribunal shall, irrespective of the country in which it was issued, be recognized as binding and, unless otherwise provided by the tribunal, be enforced upon application to the court. A party who seeks or has obtained recognition or enforcement of an interim measure shall promptly inform the court of any termination, suspension, or modification of that interim measure. And where recognition or enforcement is sought, the court may, where it considers it appropriate, order the requesting party to provide appropriate security if the tribunal has not already made a determination with respect to a security, or where such a decision is necessary to protect the rights of third parties. An arbitral award may be set aside by the Court of Appeal under our International Commercial Arbitration Act only where the party who makes the application to set aside the award furnishes proof that a party to the arbitration agreement was under some incapacity. And I did mention this earlier when I was talking about that valid arbitration agreement. The agreement is not valid, so this is another basis on which the award may be set aside. The agreement is not valid under the law to which the parties have subjected it to, or failing any indication thereon under the law of Barbados. The party who makes the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present the case of the party. And subject to subsection 2, the award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or contains decisions and matters beyond the scope of submission to arbitration. So this deals with the scope. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless that agreement was in conflict. Sorry. Before I get to that last slide. So the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless that agreement was in conflict with a provision of this act from which the parties cannot derogate, or failing such agreement was not in accordance with the act. And where the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the laws of Barbados, or the award is in conflict with public policy of Barbados. So this gives you the flavor of when it is that the award may be set aside, because these would be the bases. And as you can see, these are very, the circumstances are grave. And so a party could not just come and set aside an award simply because they disagree with it. But one of these bases would have to be established. And also, notwithstanding a section I mentioned earlier, where an award contains decision on matters beyond the scope of the submission to arbitration, and the decisions on matters submitted to arbitration can be separated from those not so submitted. Only that part of the award which contains decisions on matters not submitted to arbitration may be set aside. So I am going to close off by stopping there. But on a whole, as you can see that, the dispute resolution mechanisms set out in the building contracts and are important. It's important to understand how they operate. It's important to ensure that they're satisfying and they're fulsome in their provisions. And when you do trigger that arbitration clause, then it's important to understand the process and the role of the court, which can be a very helpful, very supportive one. And so I'll leave it there. So thank you so much for your attention.
Certainly, thank you, Nicola. You've given us a whole set of information there just now that you've gone through quite a bit. And I'm hoping that we do get some questions coming out from our guests who are here with us this evening. Something I wanted to clarify, and is a question that I've been asked or I've heard asked on occasion, and this is pertaining to the FIDIC contract and the term engineer that is used within the FIDIC contract. So in terms of who is the engineer on the FIDIC, the engineer fulfills the project manager or contract administration role in the FIDIC yellow and red books. And under clause 3.1, the engineer can be a person or a legal entity, that is a company, a partnership, etc. If they are a legal entity, then a natural person must be appointed to act on its behalf, and notice must be given to the parties as to who that person is. Whoever is appointed must be a professional engineer, having suitable qualifications, experience, and competence to act, and must be fluent in the ruling language. So just wanted to clarify that in case anyone might have been asking or wondering the term engineer under the FIDIC contract. So we've had very good presentation, Nicola. Thank you so much. And I would like at this stage to ask persons in our chat to raise any questions, queries, or comments they may have as it pertains to arbitration, etc. So just as a reminder, you can put your questions in the chat if you so wish to do, or you can raise your hand and I will call you in turn to ask your question to Nicola. Arbitration and mediation and these type of things. Obviously, this is where contracts go wrong, where you have challenges. The Royal Institute of Chartered Surveyors, which is based in the United Kingdom, they actually have a publication that came out in 2012, is termed the Conflict Avoidance and Dispute Resolution in Construction. So professional bodies do give or do have guidance as it pertains to these matters, and arbitration forms a very big part. They speak about that within that document as well. So, Nicola, how are you seeing more of a move by construction professionals to using this medium as opposed to addressing their challenges through the law courts? Is that something that is happening more now, or are persons still wanting to run down to White Park Road?
Yes, well, certainly from a commercial contract drafting point of view, I could say firstly that I do see where persons are building in arbitration in their commercial contracts, including their building contracts. And so increasingly, that is the direction of the dispute resolution selection in these contracts. But I think when I look at the contract for the BIA, I see in terms of the minor works, we do see the opportunity there for the court to be involved. And so long as people are using that form of contract, then the court will always be the place to ultimately resolve a dispute. And so I think it's important to look at. I don't think persons want to go to the court if they have a better option. And so I don't think people are drawn to going to the court because we do have the delays that we're still working on improving within the court system. And definitely for bigger projects, joint ventures, um, bigger construction projects, arbitration, and in fact, a multi-tiered dispute resolution approach is what is being taken, where parties can have different mechanisms built into that contract to be able to manage and resolve their disputes, and which would not include the courts. So for the bigger commercial building contracts, joint venture contracts, I'm definitely seeing where persons and parties are choosing an alternative dispute resolution mechanism instead of going to the courts.
So in terms of ADR, Nicola, if your contract has issues and you do have to go to a means of resolution, how much shorter is the ADR process vis-a-vis the court process? Because, obviously monies and going through a court can be quite expensive. And then the amount of time before you are granted a ruling can be, again, protracted. So can you give us an
Yes.
example of one versus the other?
Well, if I can tell you that sometimes the alternative dispute resolution process may not work as it can work because the nature of the agreement in the actual contract wasn't sufficient enough to allow for the framework required to be put in place to allow for it to work. So you sometimes find that there are where parties have chosen arbitration or some other form of alternative dispute mechanism, that sometimes it does not move as quickly as it should because there are certain things that were just not defined or clear when the parties were first entering into that contractual arrangement. But on a whole, if you do have an agreement that has the right framework in place, then it depends. So it depends on the rules here of the governing the dispute resolution, in particular the arbitration. Because under the FIDIC contract, the ICC rules, there are built-in timeframes, and so the parties are they're bound to comply with those timeframes. And so in that context, there is more predictability as to the duration, unless there's a challenge mounted, which has to be considered by the court. And likewise, when you look at other rules, such as the UNCITRAL rules, AMCC rules, there are time frames built in. So a party can look at the rules and should look at the rules from the outset of the contract to see what will the dispute look like under these rules if we were to have a dispute. How long would it take us for us to get through that dispute? And when you look at those rules, so even except where there's a challenge and those things, then you may be able to conclude, well, it looks like we should be able to get through the dispute within a year under these rules. So those types of assessment can be made looking on the time frames in the rules. And certainly if there's someone who is assisted in drafting that provision, that's the kind of question that should be asked at that stage as well. Tell me about the dispute resolution process that you're asking me to agree to. What type of time frame is involved in the resolution of this dispute, and compare it to the courts. Of course, with the court system, which I'm not currently practicing before the courts, and so I don't have a court practice, but certainly there are time frames built in there as well within which applications should be filed. But of course, there can be delays caused depending on other things that may be impacting on the dispute. And so there's less of a control by the parties in that context. And so you find that there are elements of delays that may be present there that may not be present within an alternative dispute resolution process because there's more control by the parties.
Okay. So dispute resolution board. Barbados is a very small jurisdiction. There are not perhaps a lot of persons who are au fait or maybe qualified in such an area. in the region or in Barbados, if a dispute resolution board has to be convened, how is that done? And where do we reach to convene such?
Yes. So, well, the parties themselves would need to be nominating who it is that they would wish to sit on the board. I am aware of you have very competent building professionals who could be nominated to sit on, on the board. There are attorneys as well, other professionals. So I think it depends on the nature of the project, the kind of expertise that will be required to assist in the resolution and the management of those issues. A site visit may be required, and so you would need to have someone who would understand what it is that when they do a site visit, what is it that they're looking for to be able to assess to help determine the issue that is causing the dispute. So I think that, you know, within the building professional community, there are persons there who would be quite competent to be appointed by parties to this board. And um, and outside of, you know, the building professionals, there are other professionals depending on, you know, the size contract. If it is that you may need a lawyer, there's sometimes the board may not require someone who has a legal background because it's likely the issues may deal more with the actual technical aspects of the contract. But there are some legal issues and legal processes that, especially for bigger contracts, but as you said, in our jurisdiction, unless there is a big hotel or a big project being undertaken that is being funded by maybe a developmental bank, and you find those types of projects as well tend to have in place some form of dispute adjudication board, so that the disputes which arise on those such projects can be managed throughout the course of the project. So depending on the type of issues that could arise, then you may need to look at non-building professionals. So you have a mix of persons on that board bringing different expertise to the table to be able to assist the parties work through those disputes.
Okay. So if we delve in, yeah, if we delve in a little bit now into construction arbitration, compared to the alternative dispute resolution methods, we know that arbitration is binding. It also tends to be a formal and can be an expensive process, and it carries some risk. Can you tell us, you know, does it make sense to go to arbitration vis-a-vis going to court? Since to me, it almost feels like a light version of a lawsuit.
Yes, I think it does make sense to consider arbitration instead of going to court. You, at the end of the day, when you have, but you know, before I discuss that, there are different types of dispute resolution processes. And one of the things that I have found within the building or the construction industry is that arbitration is not going to be suitable for every project, every contract. Adjudication is well utilized, and that between negotiations, you know, sometimes the parties just say, you know what, let's avoid the court, let's avoid arbitration, let's avoid everything, let's just work this out. And that's good. That's a great place to resolve disputes, right there where you can negotiate it. But then there is an adjudicator may be necessary and may be sufficient for the project to be able to make that final decision, which the parties can agree and accept, unless they want to challenge it in the courts. And that may work beautifully for the project. But in those circumstances where the choice is really the court or arbitration, I would say what the parties should consider is, one, is the control, the autonomy that they have over managing or determining certain factors about how their disputes should be resolved. And that is very valuable to a party, because the whole element of control means that you can manage your risks. And unlike, you know, when you have a matter in the court, that delay time factor is something that is is completely out of your control. But if you have a process in which you have determined what rules to use because you agreed upon it, because you understand the time frame under that rules, which you think which would be better for the resolution of your dispute, then you're controlling the process. That party autonomy is coming through and you're managing your risks. If you have a process built in as well, where you, before you get to arbitration, it's a tiered process. And very often when you have alternative dispute resolution, you have a tiered process that you can look at. Unlike when you have dispute resolution by the courts, it's, sometimes parties can try other ADR before going to the court. But if you only make provision for the court, then that is where you have to go. So I think that there is more opportunity for the parties to manage the process and the costs and the risks if they were to go with arbitration. And if it is that there are going to be unpredictable things, and if parties start making applications to the court, then the whole reason and the benefit of arbitration will be lost. If it is that parties do not have a proper basis to make an application to the court, but maybe they choose to do that in order just to slow down the arbitration process or to frustrate it. But that can always happen outside of, whether or not the issue of whether arbitration offers some advantages. But there are some advantages that it offers. And I would still say that there's great value in agreeing to arbitration under established rules with an established institution that can assist the party, or with experienced arbitrators to guide parties through that dispute. And that for me is always offers an advantage over the court system.
Okay. So let's get into some mechanics of how this thing actually works. So under construction mediation, is supposed to be an unbiased situation where you have a third party attempting to bring two parties to a mutual agreement. All right. The mediators, which is interesting here, it says the mediators are not negotiators, nor do they represent any individual party. Rather, the mediator acts as a facilitator between the parties of opposing interests. So from your perspective, having been in that process, how challenging is that, Nicola? When you have, so if I look here in this persons we have in our audience, and I say, Tony and Sean have come to you and said, okay, we have this issue. We really don't necessarily want to waste time going to court, but they're very firm and entrenched in their positions. How challenging is that to be able to get to a position when everyone will agree and walk away?
Yeah, it is very challenging. And I had to mediate a dispute between long-standing dispute. So already that meant there was a minus because it was long-standing, and so parties had become entrenched in their positions, and so it is difficult if parties are also reluctant to share information in that context, and reluctant to participate fully. Because if you're going to agree to go to a mediator to assist you in arriving at that a resolution, then there needs to be full disclosure. There needs to information needs to be shared with each other. So it's more than just a talk show. But when the mediator examines and listens to the parties and makes suggestions as to some of the things that they should consider, because those things will help them to develop their thinking on the matter, and parties have to buy into that process. And I don't know how readily persons are willing to buy into that type of process, because it's really a mature environment where you're really willing to participate and to share information and to receive that facilitation from that independent neutral third party. So it can be quite difficult, but I wouldn't say that it's not worth trying, because if you have someone with the requisite experience and the skills, and they are able to find that breakthrough point, then it would have been worth it. And I see my colleague Miles has raised his hand, and I'm so glad Miles decided to speak as well.
So
So
Miles, I invite you to unmute and participate.
Yes, thanks, Vincent, and good evening to everyone, including Nicola. Yes, I just wanted to add to that matter of mediation, because I find that the culture in Barbados, and this not only applies to the construction industry, but I think to other civil matters, is that we are not a culture that are accustomed to mediation. We somehow seem to have a culture that says, let somebody decide for me whether I am right or wrong, how much money I should get. And mediation is not about that at all. Mediation is about the parties coming to an agreement that both parties can live with. And therefore, that's why they talk about win-win. The mediator's role is not to tell them what is the win-win. The mediator's role is to guide them skillfully towards that win-win. But what I do find in the mediations that I have attempted to do is that the parties often do not, some, as you say, they come with entrenched positions. They do not want to shift from that position, and therefore it makes mediation not a useful tool. And then people say, well, mediation doesn't work. But it can only work if the parties want it to work. One of the other things I wanted to raise was Nicola mentioned the importance of having a good arbitration clause. But one of the things I found in practicing arbitration is that too often people tinker with the arbitration clause. Standard forms of contract like JCT and FIDIC and so on, and the BIA have written that contract because they know how it works. And too often I see, I'm not sure who starts the process, whether it's the clients or the professionals, tinkering with those arbitration clauses, and then in effect make them ineffective. So I've seen FIDIC contracts modified to make the engineer become the DAB. Now, clearly, the engineer cannot be the DAB because the DAB is supposed to review the engineer's determinations. And that makes the whole process invalid. I've seen people take the BIA contract and then they add a clause that says the adjudication, they take out arbitration and put in adjudication, and then say the adjudication must be in accordance with the Arbitration Act. Again, clearly not something that can happen because adjudication is a different process to arbitration. So I wonder if Nicola could expand on why it is necessary to maintain, particularly with standard forms, the clauses as they're written, and think of them at your peril. And unless you clearly understand what you're doing, leave them alone.
Yes, for sure. That is an important point because what will happen is that you end up with a clause that cannot assist you if that dispute is to arise. And so it is not workable. You would have defeated the purpose of the clause, because if it, as Mal just explained, if you have a reference to the courts when the court does not play a role at all at that point in time in any event. Sometimes you find that the court and the arbitration process, they're combined. And you're like, but you cannot agree to go to arbitration and the court at the same time, or you cannot say you're going to arbitration, but the court needs to do something for that arbitration, because then you are trying to combine two processes. And so at the end of the day, it is difficult to determine what the party's intention was and what have they truly chosen. We have seen these kind of problem clauses too, where parties may agree to have the arbitration administered by an entity that it just didn't exist in that jurisdiction. They perhaps thought it existed, but if it doesn't exist there, then what you find is that it is unworkable. So it is important when it comes to those established clauses that are in the established building contracts that you keep those as they are. Those clauses would have been developed with the requisite expertise and guidance, understanding that this is what makes them effective. And when you start pulling them apart, then you run the risk of creating something that is unworkable. And for those clauses or for those contracts where you may not have a well-defined, well-established arbitration agreement, and you are now, as the parties, agreeing to put something there, and it is best to understand, and again, going back to some of the factors I referred to earlier in terms of those essential factors to look for. Now, I would hope that one can pay closer attention to those things to make sure that you end up with a clause that is workable. You don't just say you're going to arbitration, but you have to also expand on that, because when you have that dispute, you will need to know who is going to appoint the arbitrator. How many are we talking about here? Instead of having the parties having to fight about those details at the time when they do need a tribunal to assist them to resolve it. So it's important to keep those established clauses in their usual, in their standard forms.
All right. So in our wrapping up, Nicola, two things I would like to address. Number one, how important and how challenging has it been to get the message of the arbitration out there too, in our spectrum of things, construction professionals, as a means and a way of or rather a mode to use as opposed to running to the law court, getting persons to buy into that whole concept and understanding what that is. And number two, if persons are interested in looking at this as an adjunct to their careers, professional careers, what is the process for persons who may be interested in having some sort of certification or an introduction into this this line of work?
Sure. And going back to your first question, that related to, okay, right, I remember now. So I think in answering to your first question, sensitization is important. I don't think we have enough sensitization of the alternative dispute mechanisms within the construction industry. I think that for those players that are involved in bigger projects, they're seeing these types of multi-tiered clauses. Some of them, some persons are involved in the arbitrations, or the adjudications or the dispute adjudication boards. And so outside of that category of persons within the construction industry, I don't think enough sensitization is occurring. And I think that is partly why some persons are still choosing to go to the courts. Now, even after the sensitization, persons may still choose to go to the courts, but I do think we would see some measure of increase in persons now taking on this process because they understand it. Because you see, if you don't understand the process, you're not going to buy into it. You're not going to be considering it as an alternative. So I think that this session this evening is a good one, and hopefully I would hope that persons who are in attendance have benefited from understanding more about the arbitration process that is connected to the construction industry. With respect to how it is that persons can develop maybe certain additional training, or they can undertake training or develop accreditation in this area that will assist them in their professional undertakings. There are a number of opportunities, and I do encourage And I do, and I applaud those persons who would be curious and who would want to consider looking at these opportunities, because building professionals, whether you're an engineer, an architect, a quantity surveyor, you have that technical knowledge, engineer of the construction field, and you are, I think, ideal in becoming someone who can serve as a neutral or adjudicator and an arbitrator. So yes, I certainly would encourage that. And how can you get that done? Well, we have a number of us here who are accredited professionals within the dispute resolution space. A number of us would have completed training with the Chartered Institute of Arbitrators. It's a body in London, but they offer different training in different alternative dispute mechanisms, such as mediation, adjudication, arbitration. So you could look out for the training that is publicized by them. We do have a Caribbean branch in the Barbados chapter, and we try every year actively to provide training through different courses. So we have training that is scheduled for later this year. And we can, if we haven't yet shared it with you, Vincent, we can send to you that training. And Miles, I don't know if all the slots are taken as yet, but if all the slots are not taken, then that's something that your membership could look at. For mediation, that we have another center, we have CEDA. They run the mediation training. Within the region, we have the dispute resolution in Trinidad. We have one in Jamaica, and they also undertake mediation training. But I would say the Chartered Institute of Arbitrators is one that is close by, because we have a course that we have a number of courses this year. And I think one is coming up in the summer, and then we have, so Introduction to Arbitration is on the list. We have mediation, Introduction to Mediation on the list. And then we have our International Arbitration course, I believe, is also coming up later this year. So we can share that flyer with you, Vincent, and you can share it with your membership.
For sure. I see that Miles have put in the chat, for those who may be looking at the chat, there is a link there, www.cirbcaribbean.org, which has the course information and registration forms. But Nicola, yes, you can send the information you have to the Secretariat. I see Francine Cadogan is also on the call. So the information, once it comes in, will go out to both BAPE membership and BIA membership. So we'll push it out, not a problem. Anything that will enhance our members and the professional sphere, obviously we're keen to do such. So we look forward to receiving that information and being able to send it out.
Sure, I will send it across.
All right, so Nicola, thanks so much for taking your time and to come and chat with us this afternoon. I know it's not necessarily one of those sexy topics that a lot of people may get excited about, but all the same, for us in the construction arena, it is something that we need to be aware of and understand that there are alternative means of going about dispute resolution as opposed to getting tied up in court. So I thought that was something that we needed to be expose our membership to and to have a discussion around. So thank you so much for coming this afternoon.
And thank you for having me.
Sure. Okay, guys, well, we've come to the end of this evening's session. For the July presentation for our webinar, we're going to be talking to the principal of the Samuel Chapman Prescott Institute of Technology and his team. And they're going to be telling us a bit about the mooted construction gateway and the stuff that they're going to be doing, and perhaps how some of us as professionals can get involved in one way or the other, and to have an appreciation of what the benefits can be to the construction industry. I think it's no secret that we do on island have a finite number of skilled professionals at present, and I want to emphasize on the word skilled. So this is government's way of trying to enhance the cadre of persons that are going to be available to the industry on the cusp of what can be a construction boom coming up in Barbados. Let me just check the chat to make sure there's nothing else that I have to recognize before. No, so Nicola, thanks again for joining us. And guys, thank you so much for taking the time out this evening for joining us to be educated on this very informative topic. Remember, this is a CPD event, so contact the Secretariat for those CPD points. Thank you, and I wish you a good night.